This video will be about what is wrong with the Bundys' interpretation of the United States Constitution. The short story of the Bundy Ranch standoff is as follows. From 1954 to 1993, either Cliven Bundy or his father before him entered into grazing contracts with the federal government. In 1993, when it was time to renew the contract, the federal government decided to add changes in the terms of the grazing contract. The changes in the contract would make it so that the economic viability of the Bundy Ranch would no longer be. Cliven Bundy decided not to renew the grazing contract, and he bought into a theory that the Constitution did not allow the federal government to own the land that the grazing contracts were about. He somehow concluded that the land in fact belonged to Clark County, Nevada. To his credit, Cliven Bundy tried to pay grazing fees to Clark County, Nevada, but since they did not believe they owned the land, they took the first check and then returned it to him. I will now show you a blog written by Ryan Bundy, and after that I will go over where he is wrong. Looking at the first page of Ryan Bundy's blog, he seems to skip over the first clause of Article 1, Section 8, which says, Congress shall have the power to lay and collect taxes, duties, imports, and excises, to pay the debts and provide for the common defense and general welfare of the United States. But all duties, imposts, and excises shall be uniform throughout the United States. The words provide for the general welfare of the United States essentially writes Congress a blank check to do almost anything. He does reference the 10th Amendment. It does provide that the powers not delegated to the federal government by the Constitution are reserved to the states and the people. Providing for the general welfare is a power given to the federal government, so it is not excluded by the 10th Amendment. Another thing he glosses over in referring to Article 6 of the Constitution is that treaties are the supreme law of the land. Compare the actual Article 6 of the Constitution with his paraphrase of it. Wonder why he left out the portion about treaties. The ability to make treaties is given to the federal government under Article 2, Section 2 of the United States Constitution. The land under dispute was acquired by the federal government by a treaty with Mexico. Since treaties are the supreme law of the land, the federal government owns the land in this question by the supreme law of the land. It should be noted that owning the land would be allowed under both Article 1, Section 8, Clause 1 and Article 2, Section 2, combined with Article 6, so his 10th Amendment argument just fails. If you want to see something that could have been written by George Orwell, watch this short Ryan Bundy clip and see how he talks about the meaning of the word forever.
In 1864, on October 31st, what happened? President Lincoln declared Nevada a state, did he not? I've read the speech. He declared it a state. If he declared it a state, and if it's truly a state, then it had to enter upon equal footing with the original 13 states, which means all of this land belongs to the state and their people, which means the Enabling Act, that forever, ended at that point.
Moving on to the second page of his blog. On the second page of his blog, he seems to attach some significance to the fact that the word territory is capitalized in Article 4, Section 3. At the time of the writing of the Constitution, they had different rules with regards to capitalization. Territory means a lot of different things. One meaning is just land. At the time of the writing of the Constitution, there were a number of territories the federal government would own. So if territory referred to a specific parcel of land, it should have been in the plural as opposed to the singular. It should also be noted that Article 3, Section 2 makes the Supreme Court the court that decides issues involving the United States and the United States Constitution. The interpretation the Supreme Court has given to the ability of the federal government to own land is that they in fact can own land, and they can do essentially whatever they feel like on it. See, for example, CLEP, K-L-E-P-P-E versus Mexico. Although the Northwest Ordinance was written before the Constitution, it does give some insight into what the people who wrote the Constitution were thinking at the time they wrote the Constitution. Particularly in the Northwest Ordinance, it says, the legislatures of those districts or new states shall never interfere with the primary disposal of the soil by the United States and Congress assembled. This is a clear indication that the federal government wanted to keep ownership of the land it owned in a territory after the territory became a state. The central mistake of the Bundy position is shown by their belief that by accepting a state into the Union, Congress is disposing, in parentheses, relinquishing rights, close parentheses, of the land to the people of that particular state. That proposition is just not in the Constitution and is contrary to the words of the Northwest Ordinance, duly noting that the new Northwest Ordinance is superseded by the Constitution. Moving to the third page of his blogs, he claims that the words nation and state are synonyms. However, if you look at the words of the Declaration of Independence, they are included as that as free independent states they have full power to levy war, conclude peace, contract alliances, establish commerce, and do all the other acts and things which independent states may of right do. Now compare that with the first words of Article 1, Section 10 of the United States Constitution, which are, "No state shall enter into any treaty, alliance, or confederation." From those words, it is clear that state as referred to in the Declaration of Independence is different from the word state as used in the Constitution. Another central mistake of the Bundy position is their interpretation of the equal footing doctrine. It is nowhere mentioned in the Constitution. There is some reference to the equal footing doctrine in the case of Pollard's Lessee versus Hagan, but the Supreme Court's definition of the equal footing doctrine is completely different from the Bundy one. And in the U.S. Supreme Court case of Pollard's Lessee versus Hagan, the court had no trouble with the concept that the federal government owned land. Ryan Bundy wrote, "The process to become a state is established on the equal footing doctrine, where all future states would be treated sovereign and equal. New states entering the Union would enter on an equal footing with the original 13 states. According to Article 4, Section 4 of the U.S. Constitution, all new states would be equal to the other states in every regard." When you look at the actual Constitution, Article 4, Section 4 says, "The United States shall guarantee to every state in the Union a republican form of government and shall protect each state against invasion and on the application of the legislature or the executive when the legislature cannot be convened against domestic violence." There is no mention of the equal footing doctrine as he referenced. Further goes on to write, "It is absurd to think that a newly created state equal to the original 13 must give up their land to the central government." In college, I learned that when people say something was absurd, it means they have nothing with which they can refute that assertion. Particularly the land in Nevada was never owned by the state, so they could not give it up. It should be noted that neither the state of Nevada nor Clark County, Nevada, lay any claim to the land that the federal government owns and the Bundy cattle were trespassing on. On the next page, he brings up Article 1, Section 8, Clause 17. Clause 17 is about how the federal government can extinguish state law on land that they acquire from a state. It is not at all relevant to the Bundy cattle case because the federal government does not claim to have extinguished state law on that land. At best, the Bundys have shown that the federal government does not own the land in question. Let us assume for a moment they are right. Then looking at the 10th Amendment, the question becomes, who owns the land? In the 10th Amendment, there is no order given with regards to powers exercised by the state or powers exercised by the people. question would become, who owns the land? And where in the Constitution does it say that? It is just not in the U.S. Constitution. Does it belong to the people of the state individually? Does it belong to the people of the county individually? Does it belong to all the people of the U.S. individually? Does it belong to every state? Does it belong to the particular state? The people who wrote the Constitution were smart people. They were also politicians. They would have provided an answer to those questions if, in fact, the federal government did not own the land. The Bundy position is based on things that just aren't in the Constitution, misreadings of the Constitution, and outright lies. Their view of the Constitution is just wrong, and that is why the federal government, the state of Nevada, and Clark County, Nevada, all believe that the land in question belongs to the federal government.